All right, we'll go ahead and get started. Looks like I'm a little off center. That'll be all right. So welcome everyone. My name is Chris Berry. We do these weekly webinars once a week. Mark Baugh, our retirement legacy planner, took care of it last week while I was out with a full hip replacement. So my positive focus, I always like to start with a positive focus, is something positive that happened is that I got my hip replaced and a week ago, last Tuesday, and I'm doing pretty good and back to work, and I'll be back in the office starting next week. The modern medicine, it's pretty amazing. And I appreciate all the well wishes. Nikhil, happy St. Patrick's Day. I did get those questions, so we'll go ahead and address those. And on these webinars, we answer the question, growing the beard, yeah. So my kids wanted me to grow a beard while I was out of work for the week. So see how much gray I have in the beard. I have a little bit of green undershirts, celebrate St. Patrick's Day. Thanks, Vicki. Yep, I'm doing well. But what we do is we just answer your questions live. Anything legal, financial, tax planning, we go ahead and set these up as a weekly time to answer those questions. And I had a lot of questions submitted, so I appreciate that. And if technology will work with me here, I will share my screen and we'll dig into it. Hit this button and that button and this button. And I hit this over here. And now we should be good. And as I'm going through this, I do have a lot of questions to cover this week, but if something's unclear, you do have a question on it, feel free to just put it into the chat and I'll try to answer it on the fly. And then if you do have a question that pops up, feel free to put it in the question and answer section and I'll try my best to get them answered, but I do want to make sure I cover everything. And if something, you want to see how it applies to your situation, always you can just reach out to our office, just shoot us an email or give us a call, because this is kind of general advice, but feel free to give us a call anytime at 844-885-4200, or you can book some time on my calendar by going to 15chris.com, which redirects you to our booking page. So with that, we'll go ahead and get started. So first question, I put my house into an asset protection trust. Well, not, we actually did. What happens if, when I sell, will that affect any asset protection or governmental benefits? So I use the general term asset protection trust here because there's different types of asset protection trust depending on what we're trying to do. In this specific situation, we were helping someone get qualified for VA benefits, as well as build-in protection for Medicaid. Now, the nice thing about our trusts as it relates to real estate, so think of it as we have a home, your primary residence, right? And you have certain like tax exemptions and things that go along with that. And the nice thing about our trusts is that whenever we set up one of these asset protection trusts and we move the real estate into the trust, to use a technical term, this is an important kind of tax term. These are what's called, even though they're asset protection trusts, they're called what's grantor trusts, meaning from a tax perspective, they're tax neutral. It doesn't cap any of your property taxes or anything like that. And then the nice thing, and we have these two different governmental benefits, and both of them have look back periods. We have to look back now to see if you've moved any money around. The VA benefits, so if you're a veteran or surviving spouse of a veteran, we can bring an extra $1,000, $2,000 a month to help pay for the care. Both of these programs, and then we have Medicaid, which can help pay for nursing home care, but both of these programs have look back periods, meaning they're gonna look back to see if you moved any money around. And if you have, these different governmental programs could potentially penalize you based on the fact that you've moved this money around. And so one of the questions we get quite often is that if I set up a asset protection trust, move the house into the trust, and then later I sell the property, Well, the thing is, all you're doing is changing the nature of the assets inside of the trust. You're just going from real estate to cash. But as long as it's done all within the confines of the trust, which in this situation it would be, it does not restart that 5-year clock. So let's say we set up the trust in 2017. Let's make it easy. 2015, right? So that's when we set up the trust. Now we've gotten to 2021, which means we've passed the look back period for VA or Medicaid. So everything inside of the trust is now protected. And then let's say we sell the house. Well, guess what? It does not restart the 5-year clock. So all the proceeds of the sale would be protected because we moved this piece of this asset into the trust in 2015. So that's one of the nice things about these asset protection trusts that we set up, is that, sure, you might say the home might be exempt while you're alive from Medicaid or even VA, but a lot of times our clients will want to sell their house, either downsize or maybe they need to transition into assisted living. Well, if they sell the house and it's inside of the trust, then everything inside of the trust is going to be protected from that nursing home or Medicaid's look back or the VA benefit look back. So we don't have to worry about losing our benefits. So yeah, that's the nice thing about setting up the trust, is that it's not going to have any type of negative effect on selling the house. You can do that. You don't have to worry about any other time frames or keep it as cash or anything like that. Once you've made it past the look back period, or once it's inside the trust, all you're doing is changing the nature of the assets in the trust. So you can go from real estate to cash to another piece of real estate to different investments. You can do that all within the trust. Okay, so hopefully that helps. Number 2, is a guardianship necessary to protect one's savings and life insurance before applying for Medicaid or the Michigan waiver program? We kind of have two different governmental two different Medicaid programs. The main one we deal with is Medicaid, more for nursing homes. And the reason for this is that a nursing home is going to run you $8,000 to $12,000 per month. So we're looking for any way we can to try to mitigate those costs. Then we also have what's called the Michigan Choice Waiver Program. This can be helpful for home care, and it can be used for assisted living facilities. But the problem with this is typically there's a long wait period, and it depends on how long that wait period is. It's been as long as like 9 months to 13, 14, a year and a half to qualify for the Michigan waiver program. So because there's not enough federal funds that go to it, and it's first come, first serve, this is administered through typically the Area Agency on Aging. We don't deal with the Michigan waiver program too much, just because most people can't qualify. Also, there's a income test for the Michigan Choice Waiver Program as well. So for a variety of reasons, we don't deal with the Michigan waiver program too often, just because it's not feasible for most clients. But the question here was, do I need a guardianship? The answer I would say here is typically no. And really, what we're looking at is the difference between relying on powers of attorney or disability documents versus guardianships. The big things with guardianship is that now you're having to go to court, right? So the problem here is you're going to probate court while someone's alive to be able to make decisions for them. And now it's going to be the court deciding their fate, versus this could all be handled through the proper financial powers of attorney or disability documents. So we would have a financial power of attorney to make financial decisions and a medical power of attorney to make medical decisions. It's the difference between creating your rule book versus relying on the government's rule book. And really, you're going to only need either the powers of attorney or a guardianship if you need to make decisions for someone. If you do need to make decisions for someone, ideally, we would go with well-drafted financial medical powers of attorney and a personal care plan. That'll give you the ability to make decisions for that person. Now, what that does not do, and this is where sometimes we do have to go the guardianship route, is that if the financial powers of attorney do not take away the individual's ability to make their own decisions. So if they're making decisions that are harmful to themselves, or if they really have zero capacity whatsoever, they can't sign, they don't recognize you, they're not even having lucid moments, then we might have to go the guardianship route. I call that a nuclear bomb option. It's like the last resort, because now you're getting the courts involved and you're taking away someone's independence, versus if you go the financial power of attorney routes and medical power of attorney, you're keeping things private. You're not having to basically sue that loved one to say they're incapacitated. It can be handled privately, and you can do everything basically that you could with a guardianship with financial powers of attorney. Much cheaper to set up. You don't have to worry about filing fees. You don't have to do annual accountings to the courts. So again, if possible, always try to go the power of attorney route versus going the guardianship route. But either way, they're not required to get someone qualified for Medicaid, but a lot of times you will want to have those disability documents in place because there's a lot of work that has to be done. You have to gather up a lot of information, work with different financial institutions, and especially if someone, they don't even have to necessarily be like incapacitated, dementia, Alzheimer's, they just might not want to deal with all the paperwork. And that's where the powers of attorney can be used. Even if someone's not really incapacitated, maybe they just don't want to deal with all the paperwork. We could put together powers of attorney to get that taken care of. So I much prefer the powers of attorney versus the guardianship route. See if we have any questions. No, good. All right. When do we need to file a tax return for a trust? Again, I'm going to go back to this tax term that we used. Most of the trusts that we set up are what's called grantor trusts. And what a grantor trust versus, and this is complicated. I have to go over this with some of our trusts with CPAs and financial advisors and other attorneys. I've done continued education on some of these trusts, even nationally. So understand it, this is kind of deep level stuff. Even when we're setting up asset protection trusts, the majority of our trusts are grantor trusts, which means that they're in the individual who sets it up in their Social Security number, which means it just shows up on their own Social Security or own tax return. Most of our trusts, you don't have to do separate taxes because we have a revocable living trust or even one of our castle trusts or asset protection trusts. There's a handful of times where we do non-grantor trusts. In this situation, the tax or the trust would have its own tax ID. These are called employee identification numbers or tax identification numbers. And that's where the trust would have its own tax return. Now, sometimes a grantor trust can later become a non-grantor trust upon death. So if the trust is going to operate for a period of time, so mom and dad set up a trust, and then upon death, it becomes an ongoing trust for the benefit of the kids or one of the children, then that grantor trust may become a non-grantor trust. And then upon death, we might have to get a separate tax ID number. And now that grantor trust becomes a non-grantor trust. And now we might have to do a separate tax return for the beneficiaries. But typically when you set up a trust, you're not going to have to do anything different from a tax standpoint on your trust. It might work a little bit differently upon death, depending on how the trust is set up. Okay. Number 4, and these were 2 questions I got from separate people. I kind of combined them into one. Did the CARES Act affect any IRA contributions? I'm 73 and 70. So last year, there's some changes with regards to whether you had to take out RMDs. You did not have to required minimum distributions. You did not last year because of the CARES Act, which passed in March. So if you're over 70 and a half, or actually 72, and typically you had pre-tax accounts that you had to take money out of because you had required minimum distributions, that was waived last year because of the CARES Act. Now, actually, we had something that happened prior to the CARES Act, and it seems like a lifetime ago. We had what's called the Secure Act. And the Secure Act pushed back RMDs from 70 and a half to 72, but also it allowed you to make IRA contributions post 70 and a half. So prior to the Secure Act, if you wanted to contribute to an IRA, you could not do that once you reached age 70 and a half. But now, if working, so if you still have employment income, you or a non-working spouse, thanks to the Secure Act, can contribute to your IRA after 70 and a half. So if you have employment income and you want to contribute to an IRA after 70 and a half, you can, not thanks to the Secure Act, or not thanks to the CARES Act, which really only affected last year, thanks to the Secure Act, which will continue on until further changes will be made. And then a question that came in, will RMDs be waived again this year? Not as of yet, but it may be possible. What they're talking about is they're talking about pushing back the filing from April 15th, like they did last year. They might push it back this year just because of all the changes we're having. We did have a stimulus package that just came out. Even this past week, there's been a lot of news and chatter about Biden's future tax proposals being pushed forward. So what I've been telling my clients with regards to RMDs this year, because it was interesting, the CARES Act passed in March of last year. And that's, again, what said that you did not have to take out RMDs. So if you took out an RMD in January or February, it was kind of weird because they changed the rules mid-tax year. And you did have the ability to put back the RMD, but it is odd when government changes the taxes during the actual tax year. So what I would recommend is if you don't need the RMD for income yet this year, let's wait a little bit to see at least how Biden's tax proposal, what that looks like, because that seems to be what's next on his agenda. So if you don't already have regular scheduled RMDs coming out and you take your RMD at some point throughout the year, I might hold off on taking out that RMD just because there might be some other options. Maybe instead of taking out that RMD, we do something like a Roth conversion or something else. So again, if you don't need the income yet, we don't know if RMDs will be waived this year, but I would say just hold off on taking the RMD because you can take it at any point during the year. So we might as well wait until we see what the Biden tax plan is going to be. If someone suffers an event and needs assistance with daily living activities, how long before Medicare provides help? So typically what happens, here's something, question. All right, here's a question. If you gift significant assets to your children and you need the money later, can the children gift the assets back to you? So let's say you gifted a significant amount that would be greater than $15,000 because that's your annual gift tax exclusion. Could the children then gift the assets back to you? The answer is yes, assuming they still have the money to give back to you, okay? The children might have to do a separate gift tax form back or, but yeah, they could always gift the money back if they do have the money still there. That said, I'm not a huge fan of gifting to children unless there's a specific reason why. I don't recommend gifting from an estate tax perspective outright to children, nor do I recommend gifting for Medicaid reasons. But if you're gifting because you want to gift the money to the kids because they're going to put it to something, I'm not saying don't do it, but I'm just typically not a big fan of gifting as a planning strategy. All right, number 5, if someone suffers an event, needs assistance with daily living activities, how long before Medicare provides help? Typically, it's going to be right away. So here's the typical time frame. A lot of times there's some type of event that happens. A lot of times we see it, mom or dad fall, break their hip. Ironically, I'm sitting here with a hip replacement from last week. But let's say mom or dad falls, breaks their hip. They go into the hospital. And here's the key for Medicare. They need to be going to the hospital and they need to be admitted, not under observation, but admitted for 3 days, okay? That is so key. I was giving a workshop in person back when you could do in-person workshops. And an individual came up to me and said their mom was in the hospital for 2.5 days and then she was discharged to rehab. And because she wasn't admitted for the full 3 days, the family was walking away with a $20,000 bill from the rehab. Had mom just been in that hospital admitted for another 12 hours to get to the 3-day mark, then all of that would have been waived and that all would have been covered by Medicare. So we need to be admitted for 3 days to the hospital, and then we can be discharged. And a lot of times we'll be discharged to rehab. And typically what's going to happen is Medicare will cover the first 1 to 20 days with zero out of pocket. 21 to 100, you're going to have a copay unless you have supplemental Medicare insurance. And this is why we're a big fan of getting a supplemental Medicare policy. If you have supplemental policy, then you still have zero out of pocket typically. Otherwise, it might be about $172 per day. And then after 100 days, Medicare runs out. And then also Medicare can cover things like home care for rehab. It's not going to cover like 24/7 care, but you can do some rehab at home. Now, the key for Medicare to continue to cover things, one is there's going to be a time frame at most 100 days. Second, you need to be rehabbing. You need to be participating in your rehab. So don't just assume you're going to have the full 100 days. I see a lot of families that are surprised when the nurse or social worker says, all right, Medicare is running out. We need to have a discharge plan for mom for rehab. So don't just assume that you're going to have the full 100 days. But typically Medicare is going to kick in right away, assuming you do have that life event. Another gifting question coming in. Can I gift items around my house to my kids? I'm trying to downsize my home. Does that count as gifting? Well, I'm going to give you the legal tax answer, and then I'll give you a real world answer. The legal tax answer is that you can gift up to $15,000 per year without having to fill out a gift tax form or even worrying about it. So you'd have to figure out, am I gifting more than $15,000 worth of personal items around my kid or around my house as I'm downsizing to my kids? Is that amount greater than $15,000? If it's less, don't even worry about it. If it's more, technically you should be filling out a gift tax form to notify the IRS you're cutting into your lifetime gift tax exclusion. Now, the real world answer is that if it's personal items, how do you know you own it? Like a couch, you just kind of do. So it's not going to show up anywhere. So I wouldn't really worry about gifting personal items around the house. I'll tell you one thing about it though, is maybe in terms of your overall estate planning, make sure everyone's understands what you're doing. Maybe put like a letter of instruction in your estate plan, because I've seen families come back and seen after mom passes away or dad passes away, some disagreements of like, well, all of a sudden, like this watch or this piece of jewelry showed up in so-and-so's house. Did they take it or was it gifted? So that can create some family dynamic issues, but I wouldn't worry about it from a tax perspective. Another question, first monies out of IRA has to be RMD, not Roth conversion. Correct, yeah. So if you do RMD, you can't later recharacterize that as a Roth conversion. That's why I'm recommending that you wait on taking out any RMDs this year. All right, how will my family know where my estate documents are? Should I share them now? Should my kids get their affairs in orders? So this is always a big question is how do I make sure that my family is on board with everything? And I kind of leave it up to the family in terms of how much you want to share. If everyone's on good terms and you're open with your kids, they all have good heads on their shoulders, and you really have no concerns, then I would say kind of open up the books. Give them electronic copies of everything. Make sure they know where your originals are. One of the things that we're exploring as a firm is the ability to create basically an online estate plan for clients, where everything will be housed online, and you can, so that God forbid something happened to you, we could have it trigger once we're notified, so that then maybe your successor trustee can get online access to everything that we've put together, so that everything's organized. Because we see this as a common issue. It's something that we're exploring as a firm, especially as more and more clients become more familiar or more comfortable with the online experience, because things are moving more digital. Like you're doing online banking and everything these days. So we're looking at kind of creating an online portfolio where all this information could be housed in a secure portal for successors. But for right now, if you're open with them, at the very least, tell them where these important documents are. And then also, if you are open with them, you can send them electronic copies. We always provide electronic copies of all of the signed documents. So God forbid something happened to you, they would be able to work with the financial institutions, make medical decisions, et cetera. Also, back when we were doing more in-person things, we always offered, we would do it twice a year, a successor trustee workshop, where we'd invite your family members, trustees to attend a workshop where we go over everything generally. And then if you're one of our ongoing client care program where we're meeting on an annual basis, or one of our financial clients, we can always do what we call a family meeting, where you bring your family in, whether it's a Zoom or a big 20-person conference room. And we go over a big picture of what needs to happen. We open up the documents, and we don't get into assets like mom and dad have X amount of dollars unless you want to, but we kind of do a fire drill of God forbid something happened. How would we, what are the steps? How are things handled? So if you're open with family, I would share as much as you can, because even though if everything is organized, it is a stressful situation. And we even have checklists to help people. Should my kids get their affairs in orders? Yes. I know someone that can help them with that. But yeah, anyone really over the age of 18 needs to have at least what we call disability documents. They at least need to have a financial and medical power of attorney. Because once you turn 18 legally, you're an adult. So even if you're a parent and you have like adult age kids that are away at college, God forbid something happens to them, you can't get access to their medical records. You can't make medical decisions for them. It has to be in writing. Just look at the Terry Schiavo situation. She was a woman down in Florida. She was in her mid-20s. She was incapacitated in a vegetative state. Her husband wanted to move her from life support. Her family wanted her to remain on life support. It became a big court battle, lasted over 8 years, all because she didn't have just the basics, like a financial and medical power of attorney. So should my kids get their affairs in order? Yes. And then if you are interested, again, we're working with an online kind of option for this, so that all of these documents, where all your accounts could be housed, could be shared with your successor trustee. So that's something we're kind of working out right now. All right, number 7. We have a lady, and I saw a question come in. Oh, this will fit nicely in the question. So we have a ladybird deed to our trust. We want our house to go to just one of the kids. The trust says to the trust says to all of the kids. How do we change it? Real easy. All we have to do is amend the trust. Okay. So typically what we do is, let's say you have a home, and really there's 2 ways we handle things. So first would be back up here. If we have an asset protection trust, we almost always deed the house directly to the trust. We put the real estate directly in the trust for the reason I described in our very first question. We want to be able to sell it, et cetera. So whenever we do a castle trust, whenever we're doing an asset protection trust, we deed the house directly, we deed the real estate directly to the trust. Now, if we're doing a revocable living trust, whoops, so this will be our second way to handle things. If we're doing a revocable living trust, then typically what we're doing, revocable living trust, is we do what's called a ladybird deed. And so what the ladybird deed says is the home is in your name while you're in your lifetime, and then upon death, that's when it transfers into the trust. Okay. So basically a ladybird deed is like a beneficiary designation for your home. Okay, so the home is in your name, you can refinance it, you can do whatever you want, you can sell it, and then upon death, it goes into the trust. It's like a beneficiary designation upon death flowing into the trust. And in this situation, I think we had the home going to 4 individuals, if I'm not mistaken, 2 kids, 2 grandkids, right? So that's how the trust says. And so And so the question that came in here, what are the benefits of having a house in a ladybird deed versus a trust? Well, the big thing is a ladybird deed is you're just giving it outright to a individual, and it's kind of the pillowcase of money approach. And especially like in this situation, you would have 4 people named on that deed. And now all 4 people have to agree for what it's sold for, et cetera. It becomes a hassle. Like if you only have an only child and you're comfortable giving it outright to them, you can do maybe just a ladybird deed. But if you have multiple people, you'd want just like one trustee to handle the closing and everything. So that deeding it, ladybird deed to the trust makes a lot more sense. Plus with the trust, we can build in the asset protection for the lifetime of the beneficiaries, protecting the kids from creditors, protecting the kids from divorces, making sure the money stays in the bloodline. That's only available in a trust. That's not available in a ladybird deed. Ladybird deed avoids probate, which is important, but it doesn't build in the protections, doesn't make it as easy to sell. Does the ladybird deed protect against long-term care? The short answer to that is no. You can protect your primary residence if it's valued up to $500,000, assuming you keep it as a ladybird deed. But typically, if you're concerned about long-term care, you're still going to want to deed it directly to an asset protection trust. So the trust says all the kids, how do we change it? So all we do is we just do we amend the trust to say, now I want the house to go to that one specific kid, and then everything else split up evenly. So real simple to amend the trust. All right. Let me see how we're doing on time. We're doing good. Doing good on questions. And okay. What is the difference between a castle trust and a DAPS? So a DAPS stands for Domestic Asset Protection Trust. Big thing here is with the asset DAPS, it's created by statute, and it's really only valid in the state of Michigan. Versus a common trust, common law gives it its powers, meaning it works throughout the whole US. So a big question I have is, what happens if I move? If you set up a domestic asset protection trust, it's localized in Michigan. And if you were to move to Florida or South Carolina or Georgia, you're probably not going to want a domestic asset protection trust that is only valid by statute in Michigan. Also with the DAPS, so I'd say this is a negative. You have to give up control. You cannot be the trustee, cannot make changes. And, non-grantor trust. So it screws up your taxes. And I was kind of part of the group of attorneys working on the asset protection, the DAPS for the state of Michigan and the State Bar of Michigan. So it serves its purpose, but again, a castle trust typically is going to be the route that you want to go, because the castle trust, you can make changes. Grantor trust, big one for a lot of my clients. You can move out of state. You can be the trustee. So really, I cannot foresee any reason why you would want to choose a domestic asset protection trust versus a castle trust. Now, I might be asking, well, where did they come from, domestic asset protection trust? Or why did the State Bar of Michigan and the legislature put that together? Because they wanted a paint by numbers approach for maybe less sophisticated attorneys, where if you follow like step by step all of these rules, then you'll know the state of Michigan is going to protect you. Versus the castle trust, which is valid in Michigan as well as other states, more complicated. You need to know the ins and outs when you set it up. You have to have a deeper level of knowledge. That's why I'm a certified elder law attorney. And elder law is like asset protection. a code word for asset protection, in addition to be an investment advisor. And there's, I think, maybe 18 of us in the state of Michigan, maybe 500 across the whole nation. So if you know how to set these up right, you don't have to rely on this kind of paint by numbers approach that you're really boxed in. So that's where the Castle Trust, I think, is much better than a domestic asset protection trust. Question I get often is, has it been tested? Castle Trusts have been tested. Yes, they've been tested in courts, in divorce court, for Medicaid, for our trusts have been challenged by the VA. So yeah, they've been tested and they're valid. So again, I can't see a reason why I would, for any of my clients, because I understand how to do this, ever recommend a domestic asset protection trust. And I think state of Michigan, it was probably 5 years ago. I could be wrong. That's just off the top of my head. Comment came in. Thanks so much, Chris. Have to duck out now. Great information. Oh, thank you. When should someone consider a LURP versus Roth for tax-free income? What are the pros and cons of a LURP? What is the best structure for a LURP, if there is one? Is a LURP feasible in retirement? So in my world, we have so many different acronyms, but a LURP, I like it. And I've talked about these before. I just haven't used, I don't often use the term LURP. What it is life insurance, retirement plan. And I think the term was coined by someone I've worked with, actually, and I'm a big fan of, David McKnight. He wrote a book called The Power of Zero, and then he wrote a book, kind of follow-up book called Look Before You LURP. Big fan of David McKnight. Now, understand, really, David McKnight, all he does is sell life insurance, which is not necessarily what we do. Not at all, actually, what we do. I'm a fan of life insurance, and life insurance is a tool, but really all a LURP is cash value life insurance. Typically, what we're doing is we're using index universal life. So whenever I use the term index, let me, hold on. I'm not sure if my screen is showing as I'm writing. So let me just, whoops, kind of reshare my screen real quick. I hit that button and that button. No, all right, yeah, good. All right, so what is a LURP? Really, it's a cash value life insurance. And typically what we're using is what's called index universal life. Now, why you might want, there's different benefits of using a LURP or cash value life insurance, IUL. First of all, tax-free income. So I have a cash value life insurance. A lot of my clients, we put together kind of LURP plans or cash value or IUL life insurance for tax-free income. I'm younger. Most of my clients are older, but this is one option when you, like this might be good for maybe your children, if you have children that are, say, age 30 to 40 and they're accumulating wealth. I'm still accumulating wealth. I'm putting money annually into this, and I'll do so until retirement. I can pull money out of this LURP or IUL tax-free. So I'm using it as one of the ways to pay for my kids' college education in 10 years. So I'm putting money into this for 10 years. I'll be pulling some money out in 10 years because it grows tax-free. So that money can be used to pay for my kids' college tax-free. I'm going to keep contributing to it because I'm going to use it in retirement. And this is where a lot of my clients utilize this, is they use it for tax-free retirement income. Most of my clients who do these types of policies are, I would say 55 to 70. So that would be where most of my clients are. So there's one strategy for those within that age bracket where it's about protecting what you have. Then we kind of have accumulation strategies as well. And we would set up the policies different. And it's a multifaceted tool. I could do a whole hour on planning strategies. So one would be tax-free income. And where a lot of my 55 to 70s year olds and even older are utilizing these, are just understanding like tax buckets. So you have your taxable bucket, you have your tax deferred. So this is like your IRAs, 401ks, money that's pre-tax, and then tax-free. This would be things like Roth, LERP, or IUL. I use IUL, it's less letters. So what a lot of my clients are doing, because they think taxes are going up in the future, is they're moving money from the pre-tax account over to the tax-free account. Granted, you have to pay the tax, and we're doing things like Roth conversions, we're doing things like IUL, or some combination of both. So tax-free income is nice. Now, would you recommend converting non-Roth money into a LERP, into a Roth IRA? Would you recommend converting non-Roth IRA money into a LERP versus into a, well, so Doug, you cannot convert non-Roth money. Let me rephrase that. You cannot convert tax deferred money. I'm sorry, let me try this again. You cannot do a Roth conversion from a taxable account. So you cannot do a Roth conversion from a taxable account. Roth conversions have to happen here, okay? But what you can do is you can move money to an IUL from a taxable account, or you can move money from your tax deferred to the IUL. So why do a IUL or a LERP? You get tax-free income. You can get a death benefit that can double as a long-term care benefit. So this is something that appealed to me. Let's say I have a $500,000 death benefit. Well, when I'm older, maybe I'm not concerned about a death benefit, but that $500,000 death benefit doubles as a long-term care benefit for home care, assisted living, nursing home care. It can create legacy. So I have a lot of clients that are looking at this as a legacy play to leave more money tax-free based on their health and their age to their kids, because maybe it's $100,000 if they do Roth conversions, which are tax-free to the kids, or it might be $200,000 of tax-free death benefit to the kids, depending on your age and health. But a big difference, and I'm not saying it's better, it's just different. And so one of the things I'm always looking for is diversification. That's how you protect against risk. Different types of risk, right? You wouldn't have all your money in a specific stock, right? Because if that stock went down, you just lost your whole retirement. So we have like diversifying against market risk, right? You don't want to have everything in one stock, right? Well, you also want to diversify against tax risk. You don't want everything sitting in tax deferred bucket, because if taxes go up, then the value of your accounts go down. But also we can have diversification of index. Like one of the advantages of IUL is you have downside protection. Okay. So this is why you might want to look at, just from an investment standpoint, if we have the Roth, and again, I'm not saying not to do a Roth. And really our process with this, and I apologize for jumping around, but first is we figure out how much to convert or how much to move, looking at your taxes. And then second, where to put it. And the where to put it, so the how much, it's a numbers game. And we can run the numbers for you, it's super easy. Where to put it, that's where we get into actual planning. What are your goals? What do you want to accomplish? But with the Roth, understand it's typically invested in the market. So you're going to see it go like that, okay? Similarly, as I'm saving for the for my kids' college, I'm saving in a 529. It's going to go up and down as a market, right? But if we have a 2008, right before we need the money, then we're subject to market risk. Versus like an IUL, because it has the power of indexing, it's going to go up like this. If the markets go up, you're going to collect the upside of the market. Markets go down, you're going to remain where you're at. So that's why we might just ballpark, if you're looking at like diversification, as you're moving money into this tax-free bucket, maybe you put 50% into the Roth, 50% into the IUL, because you have indexing, diversification, plus maybe more of a legacy benefit if you pass away, you can build in long-term care as well. So I'm not saying everyone needs a IUL or a LRP. There are downsides to it. It's time consuming to set up. It's complicated, but that's where we go nice and slow. And one of the reasons we want to provide education. So again, our approach is figure out what are your goals, what are the best strategies, and then pick the right tool. I really like the IUL or LRP as a tool. I'm not saying it's right for everyone. I myself have one. I also have Roth money. I also have 529 money. I have money in the market. So I'm not saying it's the end all be all, but it is an interesting tool that's a little complicated, but it might fit into overall planning. So Doug, hopefully that answered your questions on that, and more than happy to dig into what is the cost of IUL. There's no like cost per se. You do have what's called a mortality expense. So understand that there is going to be something that goes to funding the death benefit or long-term care benefit, but there's no actual cost to a IUL. This is different than like term life insurance. So you might be thinking, well, I don't need life insurance. We're not really looking at this specifically for the life insurance component. Like if you had a need for life insurance, first we'd look to like term life insurance, especially when you're younger, you're working, you want to cover a mortgage, it runs for a term, that has a cost. This is more of an investment. And typically the best way if you want to learn about it is let's set up a call to figure out what you want to accomplish, because depending on what your goals are, if you want tax-free income, then we're going to set up the policy differently than if you're looking at strictly a death benefit or long-term care benefit versus if you're looking at it strictly as a legacy play. Like the policy would be set up differently. Because think of this as like a pie. There's different ways that we can break up this IUL. Like what are its different purposes? We could have it all to legacy, or maybe you want income and legacy. It's kind of an interesting tool. It's like a Swiss Army knife that can be really good at specific things depending on how you set it up. Like we can have it where it could do all things, or it could do just one of those things really well. That's where, again, these are complicated. That's why I spend more time on something like this than say a Roth conversion. Roth conversion, it's pretty easy. How much to convert, and then what do you invest in it? Versus a IUL, it's like, first of all, do I need one? Do I want one? If so, what one do I want to set up? Is it right for me? There's a lot more that goes into it. All right. Number 10, IUL protects against downside, but typically are not good growth vehicle, but has side benefits of death. So Doug, I'm sorry, that's a single someone out. Someone writes in that it's not a good growth vehicle. I would push back on that because depending on how it's set up, like mine and a lot of my clients, if we're setting it up as tax-free income, it can be an amazing growth vehicle because you have downside protection and you have tax-free income. You can see rates of return of, like I can't make guarantees and talk about, I need to make sure that past performance doesn't equal future performance, but my quarterly policy just came in and it had over an 8% rate of return. So that's pretty good for something that has downside protection. So depending on how you set it up, it can be a very good growth vehicle. It can be a very good accumulation vehicle, depending on how the IUL is set up. If you want to set it up for growth, it can be an amazing growth vehicle. And in fact, if you email me, I can show you a chart that shows that over the last 20 years, depending on how the policy has been set up, IUL has actually outperformed the market over the last 20 years because you're taking out the downsides. So again, could you Angela writes in, could you change term life to IUL? Typically, no, unless you originally took that as an option. And even then, your term policies, they might be able to be turned into permanent policies, but you wouldn't be able to turn it into an IUL. What you could do And what some people do, and I'm not saying rush out and do this, is you can stop paying on that term policy or stop paying on that long-term, pure traditional long-term care insurance policy, and instead invest that money into a permanent option. But again, I'm not saying do that. We need to see kind of what we'd be giving up if we were to do that. Last couple questions here. I want to make sure I get them done within the last 10 minutes. Our mom is in good physical condition, but her Alzheimer's is nearing the point of her needing more care. She hasn't done any planning. Is there anything we can do to protect her assets from Medicaid nursing home spend down at the last minute? The answer is yes. We can always do what we call Medicaid crisis planning. To be honest, I could do a whole hour on how this works, but really we have two main strategies. One, if we have a single individual, one, if we had married with one spouse needing care. But long story short, even within that 5-year look back period that we talked about, that Medicaid had this 5-year look back period, there's things we can do if you have a loved one in a nursing home right now. Typically, we can put together a Medicaid crisis plan to protect at least or right around about 50% of the assets. So if you had a loved one in a nursing home right now paying $12,000 a month, we could put together a strategy to protect roughly half of her assets or his assets. It's complicated how we do it. It's messy. I much prefer planning ahead. Much easier, much less costly to do that type of planning, much less stressful, much less work on your part to get us all the information. So again, if there's one thing to take away from these, the earlier you start thinking about these ideas and start planning, the more options you're going to have on the table and the better those options will be. Last question that came in ahead of time. What is it about a trust that keeps it private while a will has to go through probate? Why isn't a simple letter that indicates where stuff should be treated as a valid, or why shouldn't that be as a valid document? So with this, my answer is don't kill the messenger. Like, I didn't create the laws. I didn't create the rules. What happened is people did things and there weren't rules around them. People took advantage of them, and then people created rules. One of my goals this year is to read 52 books, and I think I'm 18 into it. I have a stack of books I want to read versus a stack that I've already read, and I think I have 18. I'll have to double check. But a lot of the books I'm reading are like biographies on some of the great families and great men in finance. So I read books on the Rothschilds and Rockefeller and the House of Morgan and how the Morgan Bank started. And then now I'm thanks to a referral from a client, and I can't remember who it was. And if you're on the webinar, I'm sorry I forgot your name or I forgot who recommended. But as I've been laid up with this hip replacement, I've been watching on Amazon Prime a series that was done in 2012 called The Men That Created America. I might be butchering the title, but it's on Amazon Prime, and it's basically a documentary where they hire actors to play some of the roles, but it traces the Vanderbilt family to the Rockefellers to the Carnegies to the Morgan family to Henry Ford. But one thing I take away from that is just how ruthless business used to be back then. And we look at like unbridled capitalism, and not to get into a political discussion, but some of their activities were pretty ruthless, hiring Pinkertons and everything like that. So the reason I share that is the reason we have these laws is because people have done things, and 90% of the time you would think that, okay, just a handshake deal should work, but there's the 10% or even less, the people that screw things up. Like if you look at the common thing is look at the mattress, right? Your bed mattress has that thing that don't rip this off. It's illegal to rip off this tag. Like someone had to rip that tag off and like done something. Or the McDonald's cup where, or you look at the silly warnings on different things like batteries, don't eat a battery. Now we have to have a legal warning on it. So I don't know why it has to be so difficult, but yeah, the way that our laws work, wills, go through probate court. And probably the reason why that we have the rules is because of the family dynamics. People are fighting over different things when mom or dad passes away. So they had to codify how to create your rule book. So things have to be witnessed a certain way. Things have to be notarized. And so a will gives instructions to the probate court. Certain formalities have to be followed. A will, unless it's written in your own handwriting, has to be notarized. You can have two witnesses with it. A trust, and this is one of the reasons I got into reading about the Rockefellers and the Morgans and the Rothschilds, is looking back at these early trusts, which was kind of interesting, and how trusts have evolved since then. But yeah, trusts are private documents. Trusts are basically a legal contract, so it follows different rules than a will. But my job is to take the stuff that's super complicated, whether it's legal or investment strategies, and my job is to kind of nerd out. It's my kid's favorite word right now. Is they're reading, my 8-year-old daughter is reading a 400-page book, and my son got some books on like the Holocaust. He's 10, from the book fair he was at. And so common word they're throwing around, and as they're watching me read these kind of bigger books, their common word for them is nerd. And we're trying to tell them nerd's a good thing. Nerds kind of run the world. But it's my job to nerd out on these complicated things and try to make them as simple as easy to understand as possible. So, but that said, I don't create the rules, the Medicaid rules, why life insurance falls into code 7702 of the tax code to be tax-free. I don't create the rules, it just kind of happens. So with that, that was all of the questions that were submitted ahead of time. Anyone have any last questions? So great series. Thanks, Vicki. My pleasure. It's great to be back in the saddle. Here's a question just came in. If I put the ladybird deed in the trust now versus waiting till my death, would I still be a ladybird deed or owned by the trust? So again, typically what we're doing with what a ladybird deed is, basically a beneficiary designation for your home. So the home is titled in your name. You're the owner of it. And then upon death, then it flows into the trust. The ladybird deed is recorded right away. So we take it to the register of deeds so they know that it's in your name for your lifetime. And then upon death, it goes to who we've listed as a beneficiary. Typically, that'll be the trust. So let me reread that question. If I put the ladybird deed in trust now versus waiting till my death, would it still be a ladybird deed or owned by the trust? Yeah, so if you do the ladybird deed now, because it's a beneficiary designation, it's owned by you while you're alive, and then only upon death does it flow into the trust. So versus if we were to set up an asset protection trust, we would deed it directly to the trust, and the trust would be the owner. And typically we would have you as the owner of the trust, and then you could sell the house and do whatever you want, refinance it within the trust, but you would do it as trustee of the trust. Thanks, Chris. Thanks, Chris. Great job as always. Glad to hear you're feeling okay. Thank you, Elaine. Joe, thanks again. This was a great review. Glad to have you back. Thank you so much, Joe. Great to be back. So with that, thank you, everyone. Thank you so much. I appreciate it. Make it a great week. And I look forward to seeing you next week. Make sure to share this. The more people we have on, I love these questions. And I really appreciate everyone logging on and submitting their questions. I love the interaction, especially as we're still a little bit locked down.